Good evening. On Friday, a federal appeals court handed the Trump administration a major legal victory. And the irony, the judge who wrote the opinion was appointed by Barack Obama. The Fourth Circuit Court of Appeals ruled that Trump's executive orders banning diversity, equity, and inclusion programs across federal agencies and government contractors can move forward. The court overturned a lower court injunction that had blocked these orders for nearly a year. This is big, because we're talking about every federal agency, every company that does business with the government, every university that receives federal grants. All of them now required to certify they don't operate DEI programs or lose their funding. Tonight, I'm going to explain what this ruling means, why even an Obama-appointed judge sided with Trump, and what happens next. Because this fight is far from over. If you want legal analysis that breaks down what courts actually said, not what pundits claim they said, subscribe to Capital Prime right now. Hit that bell. We're going deep on this one. Let's begin. Friday, February 6th, 2026, the Fourth U.S. Circuit Court of Appeals in Richmond, Virginia, issues its decision. A three-judge panel unanimously overturns a preliminary injunction that had been blocking Trump's anti-DEI executive orders since February 2025. The opinion was written by Chief Judge Albert Diaz. And here's what makes this remarkable. Diaz was appointed by President Barack Obama. This wasn't a Trump judge. This wasn't a conservative activist on the bench. This was an Obama appointee ruling in Trump's favor. The panel also included Judge Pamela A. Harris, another Obama appointee, and Judge Allison Jones Rushing, a Trump appointee. Unanimous decision. All three judges agreed. So what did they actually rule? The court said that Trump's executive orders cannot be challenged facially, meaning you can't challenge them in the abstract before they're actually applied. Instead, legal challenges have to wait until federal agencies enforce these directives against specific grant recipients or contractors. Only then can someone sue based on how the orders were implemented. Judge Diaz wrote, President Trump has decided that equity isn't a priority in his administration, and so has directed his subordinates to terminate funding that supports equity-related projects to the maximum extent allowed by law. That's the key phrase. To the maximum extent allowed by law. The court is saying Trump has the authority to set policy priorities. If he doesn't want federal money going to DEI programs, that's his prerogative as president. But Diaz also wrote a separate concurring opinion, a personal note, essentially where he said he reached this conclusion reluctantly. He acknowledged that the evidence suggested what he called a sinister story in which programs were being terminated simply because they used certain keywords like equity or inclusion. And then he wrote this, for those disappointed by the outcome, I say this, follow the law, continue your critical work, keep the faith. So even the judge ruling in Trump's favor doesn't like what's happening. But he's saying the law is the law. Let's back up and talk about what these executive orders actually say, because there's been a lot of confusion. Trump signed these orders on his first day back in office, January 20th, 2025. There were multiple orders, but the key provisions do three things. First, they direct all federal agencies to eliminate DEI programs within their own operations. No more diversity offices, no more equity task forces, no more inclusion training, gone. Second, they require government contractors and grant recipients to certify in writing that they do not operate DEI programs. If you want a federal contract, if you want a federal grant, you have to sign a statement saying you're not doing DEI work. Third, they instruct federal agencies to work with the Justice Department to investigate companies with DEI policies and take measures to deter these programs. That last part is what really got people's attention. Because it's not just saying the federal government won't fund DEI, it's saying we're going to actively investigate and deter private companies from having DEI programs. The plaintiffs, Baltimore, the National Association of Diversity Officers in Higher Education, and the American Association of University Professors argued this violates the First Amendment. They said it's compelled speech to force contractors to certify they don't have DEI programs. They said it's viewpoint discrimination to punish organizations for supporting diversity and inclusion. And initially, a lower court judge agreed with them February 2025. U.S. District Judge Adam Abelson in Baltimore issues a preliminary injunction blocking Trump's DEI ban. Judge Abelson, also an Obama appointee, by the way, ruled that Trump's directives likely violate the Constitution, specifically the First Amendment's free speech protections and the Fifth Amendment's due process requirements. His reasoning: the orders were too vague. What counts as a DEI program? What's the difference between a lawful diversity initiative and an unlawful one? The standards weren't clear, and that's a due process problem. He also said the orders appeared to punish organizations based on their viewpoints about diversity and inclusion. If you believe in equity, you lose federal funding. If you don't, you keep it. That's viewpoint discrimination, and the First Amendment doesn't allow that. So Abelson blocked the orders. For nearly a year, they couldn't be enforced. But the Trump administration immediately appealed. And in March 2025, the Fourth Circuit put Abelson's injunction on hold while they considered the appeal. That meant the DEI ban was partially in effect for the past 10 months, even though it was still being litigated. And now Friday's ruling makes it official. The injunction is overturned. The ban is fully in effect. So why did the Fourth Circuit overturn Judge Abelson's decision? It comes down to something called ripeness. In legal terms, that means, is this case ready to be decided? Has the harm actually happened yet, or are we just speculating about future harm? Judge Diaz said these executive orders are instructions from the president to his subordinates, federal agency heads. They don't directly regulate private companies or universities. They tell agency heads, here's my policy. Implement it to the maximum extent the law allows. So the court is saying we can't evaluate whether this violates the Constitution until we see how agencies actually apply it. If an agency terminates a contract in a way that violates free speech, then the contractor can sue that agency. If an agency cuts off grant funding improperly, the university can challenge that specific action. But you can't challenge the president's general policy directive before it's been applied. Diaz wrote, "The executive order's plain text doesn't terminate any contracts, nor does it directly regulate non-governmental conduct." Trump telling his people what to do isn't the same as Trump directly regulating private behavior. And until those instructions are actually carried out in specific cases, there's nothing for the court to review. Now, that's a legal technicality. And a lot of people are going to be frustrated by it because what it means in practice is the DEI ban goes into effect, federal contractors start losing contracts, universities start losing grants, and only then, after the damage is done, can they sue. It's the legal equivalent of, we'll cross that bridge when we come to it. The White House was thrilled with this ruling. White House spokeswoman Abigail Jackson issued a statement calling it a big win. She said the administration has proudly put an end to unlawful DEI discrimination in the federal government. Notice that framing, unlawful DEI discrimination. The Trump administration doesn't call these diversity programs. They call them discrimination. They argue that DEI initiatives are inherently discriminatory, usually against white people, usually against men, usually against conservatives. That's been the conservative argument for years. DEI is reverse discrimination. It's unconstitutional. It violates civil rights laws. And now, with this court ruling, the Trump administration has the legal green light to enforce that view across the entire federal government and every organization that takes federal money. Universities with diversity offices, they're on notice. Fortune 500 companies with equity programs that also hold federal contracts, they're on notice. Nonprofits doing inclusion work funded by federal grants, on notice. Certify you're not doing DEI work or lose your funding. The plaintiffs obviously are not happy, but they're not giving up. Skye Perryman, whose liberal legal group Democracy Forward represented the plaintiffs, noted that the ruling left the door open for future challenges. She said in a statement, "We are looking forward to continuing to litigate this case in the district court." What does that mean? Remember, the appeals court said you can't challenge these orders in the abstract, but you can challenge them as applied. So Democracy Forward and their allies are going to wait for federal agencies to start cutting contracts and grants, and then they're going to sue based on those specific actions. They'll argue this contractor was terminated solely because they had a diversity program. That's viewpoint discrimination. That violates the First Amendment. Or this grant was pulled because the university mentioned equity in their research proposal. That's compelled speech. That's unconstitutional. Those cases are coming. This fight is not over. And there's another layer to this. Private lawsuits. Companies and universities that lose federal funding might also sue under employment discrimination laws, contract law, or other legal theories. This is going to be litigated for years. So let's talk about what this actually means on the ground. If you're a federal contractor, let's say you're Boeing or Lockheed Martin, or any company that does billions of dollars in business with the government, you now have to certify that you don't have DEI programs. If you have a chief diversity officer, you might have to eliminate that position. If you have diversity training, you might have to end it. If you have hiring goals related to increasing representation of women or minorities, those might have to go. If you're a university receiving federal research grants, and most major universities receive hundreds of millions in federal funding, you have to certify you're not operating DEI programs. Does that mean you can't have a diversity office? Can't have scholarships for underrepresented students? Can't have faculty hiring initiatives aimed at diversifying your department? Nobody knows yet because the Trump administration hasn't issued clear guidance on what counts as a prohibited DEI program. And that's intentional because vagueness creates fear. If you don't know exactly what's allowed and what isn't, you're going to be cautious. You're going to err on the side of eliminating programs rather than risk losing federal funding. That's how this works. The threat is the enforcement mechanism. On Friday, a federal appeals court ruled that Trump's ban on DEI programs across federal agencies and government contractors can go forward. An Obama-appointed judge wrote the decision. The ruling was unanimous. The court didn't say DEI bans are constitutional. It said they can't be challenged until they're actually applied. So now we wait. We wait for contracts to be terminated. We wait for grants to be pulled. And then the real legal battle begins. The Trump administration calls this a victory over unlawful discrimination. Critics call it an attack on civil rights and free speech. Subscribe to Capital Prime, because we're going to follow every lawsuit, every enforcement action, every legal challenge that comes out of this. This story is just beginning. Let me know in the comments. Do you think DEI programs should be banned from federal agencies and contractors, or is this government overreach? This is Capital Prime. Good night.